Sharon Fox is a lawyer in Regina. Sharon, you read the decision in the Leslie Black case. Explain why the judge decided that Leslie Black would not be designated as a dangerous offender.
When we read the decision of the court in the Black case, what we see is the court being concerned about Mr. Black's ability to be rehabilitated. What we know about dangerous offender applications is that the focus is no longer on the rehabilitation of the offender, but separation of them from society and protection of the public. In Mr. Black's situation, he had not been given an opportunity to go through an intensive rehabilitation programming. The experts in the case who had done the psychiatric analysis on him were inconclusive as to his ability to be rehabilitated. And so what the court did in that situation was order a long-term supervision order rather than a dangerous offender designation, which would allow him to participate in lengthy and intensive rehabilitation efforts to determine if he has the ability or means of being rehabilitated.
Leslie Black's crime was particularly egregious against Marlene Bird. What does it take for someone to be labeled a dangerous offender? What's the criteria?
In 2008, the Harper government brought in significant amendments to the dangerous offender legislation, and essentially where certain criteria have been met, it's incumbent upon the court to designate an individual a dangerous offender. One of those criteria is that the offense be a serious personal injury offense, such that the nature of the offense, one of the criteria can be that it is of such a brutal nature, even though there may not be a past pattern of offenses of this kind. And that was what we saw in Mr. Black's case, is he had some violence in his record, but it wasn't this brutal and ongoing escalating type of violence or continuing type of violence. It was a single incident and event that brought about the application for a dangerous offender designation.
How many dangerous offenders are there in Canada?
According to Canada statistics, at the end of 2014-2015, there were approximately 735 dangerous offenders in Canada. Approximately 23% of those are Aboriginal or First Nations descent. In Saskatchewan, however, we see an even starker contrast, with about 80% of our dangerous offender applications or dangerous offender designations being Aboriginal or First Nations people. In Saskatchewan alone, we have approximately 98 dangerous offenders, of which 4 are women. So the numbers are not insignificant in that regard.
What do the numbers tell you? Why is there such a high number of dangerous offenders in Saskatchewan in particular?
A number of the reasons can be linked back to the 2008 amendments that we saw Stephen Harper's government bring in respect of crime and getting tough on crime. We saw over 30 changes to criminal law legislation, making it harder to obtain a parole, increasing the length and minimum sentences, and as well making it more difficult for young people, young offenders, to avoid jail time. So that is certainly one cause. Another indication really relates to the social climate of First Nations people in Canada, relates back to the residential school system. We see intergenerational trauma, we see intergenerational violence and loss, which obviously impacts families in generations to come. And so there's also evidence of a social stigma. There's evidence of systemic discrimination that has certainly played a role in the status of Aboriginal persons in our criminal justice system. And I think when you look back at the decision of Mr. Justice Murray Sinclair in the Truth and Reconciliation report, he notes, and I think fairly so, that Aboriginal peoples are no more violent, no more genetically predisposed or inherently criminogenic than the rest of the population, which leads one to the conclusion that there are social and environmental factors that are bringing about the statistics that we're seeing here today.
Thanks for your time today, Sharon.
You're welcome.